And welcome back to Legal Matters, everyone. I'm your host, Alan Jones, and with me now is Mark Brynteson. He's the managing attorney for the American law firm. As a reminder, this is a half-hour informational news call-in show devoted to a variety of legal topics of interest to many of you, the viewer. We have attorneys standing by now to take your call at the number on your screen. They'll be able to provide you with free information regarding your legal issue, so call now and throughout the next hour. So our opening statement tonight will be discussing proving fault in slip and fall cases, and then later on we'll talk about corporate law. But first, let me remind you of the multiple practice areas that the American law firm concentrates in. American Law Firm is a general practice law firm that concentrates in divorce and family law cases, bankruptcy matters, personal injury claims, criminal traffic and DUI issues, wills, trust and probate matters, real estate and business transactions, along with immigration and naturalization services. So please feel free to call now and discuss any of these areas with attorneys who are standing by. So Mark Brynteson is with me today. And Mark, welcome back.
Well, thank you.
We've got a nice half hour of good information. Talking first about slip and fall cases. So what are the critical components of a successful slip and fall case?
Well, believe it or not, the most important is you have to know what you fell or tripped on. In many of these cases, the person, when they go down, they may be unconscious. They just don't know what happened because they're in a lot of pain. Mm-hmm. And if you can't prove what you fell or you tripped over, you will lose the case. So that means there needs to be investigation done right out of the box to find out what happened. That could be preserving the videotape of the premises where you fell. That could be a grocery store, it could be a mall, which they usually have videotapes. If they destroyed the videotape up, in close proximity to the time you fell, and you go to trial, there could be a jury instruction that that tells the jury you can presume that they destroyed it. It would have been damaging to them, and that's good for you. There are multiple things in trip and fall cases, but the first and foremost is you have to know what you tripped or fell over. Okay, so actually, if you think trip or fall or whatever, especially this time of year, it's mostly ice. But there are other things that obviously have to be considered in that. Oh, yes. Not only ice, but in the summer times you can have runners, little carpet runners in stores. One of the main things we see is in places such as grocery stores, etc., where you have a lot of maintenance going on throughout the day. People will come and the store employees will mop up messes and they'll forget to put down a warning sign. And that's key. Anytime that an employee of the owner of the premises, if they create the dangerous conditions such as mopping and making it wet and they forget to warn, that's automatic liability generally. So there are many ways, and that can happen in the summer. It doesn't have to be winter, but it can happen in the summer. We see these cases all the time. And generally, trip and fall cases, if you can believe it or not, are much more, the injuries tend to be worse because they'll hit their head, they'll break a bone. I've seen trip and fall cases where the medical bills were over $200,000 alone. So trip and fall cases actually tend to be greater injuries than rear-end auto accident case.
Yeah, I would probably believe that well, you just tripped. It wasn't anything serious. You skinned your knee or whatever. But depending on where it happens, then it becomes a lot more serious. If you're slipping in water on a tile floor and fall down and hit your head, that's going to be a lot worse than tripping over a ball in somebody's yard.
Absolutely. Well,
yeah.
Do you remember, it was several years ago, it was the lady that played on The Parent Trap. She was skiing and hit her head. She was married to Liam Neeson, the actor. And
yes.
She was just skiing and went down and hit her head on the snow. It was hard. And she got up and continued skiing and died a few days later of a cerebral bleed in the brain. They couldn't fix it. So imagine going down on a tile floor. It's nasty. It's very nasty. You can generate a lot of force from somebody that's 6 foot, 5.5 feet tall. By the time they fall and go down to the floor, you can generate a lot of force enough that can kill you with the fall.
As a reminder, if you have any questions, be sure and call in the number 815-394-1776. So how do you prove who's at fault and what are the immediate steps you have to take into account?
Well, first, like I said, you have to know what you tripped or fell on. Second is notice. The premises or the owner of the premises, or let's say somebody is leasing or renting the premises, a business establishment from a landlord, you need to know exactly if they had notice of the dangerous condition, and that's twofold. It's one, they actually knew, and that was the example I gave a little earlier of the employee mopping the floor. If they created or put the dangerous condition on the floor or on the premises, then they knew about it. The knowledge of the employee is imputed or transferred back to the owner or the landlord of the premises. The next part is should have known. A lot of clients, when they walk in and I'm explaining this to them, the best example I can give is if you're in a grocery store and a grape were to fall from the produce section, it's on the floor. If you step in that grape 3 seconds later, there's probably not any liability. But if that grape stays on the floor, let's say for 30 minutes, 60 minutes, and the store owner has a policy of going around and looking looking at the premises and the floor in the produce section every 20 minutes, and they didn't follow it, and that grape is now dirty, black, that means they should have known. Even if they didn't have actual knowledge, they should have known if they would have followed their policies. And that's another way. So they either knew or should have known. So you have to know what you tripped or fell on, and you have to prove that the owner of the premises knew or should have known that it was there.
Okay. All right. Well, we have more to come. We'll be talking more with Mark Brynteson in just a moment. You're watching Legal Matters with the American Law Firm. And welcome back. I'm your host, Alan Jones. With me is Attorney Mark Brynteson with the American Law Firm. We are watching Legal Matters, an informational and news call-in show devoted to a variety of legal topics. Attorneys are standing by now to take your call at the number on your screen. That's 815-394-1776. They'll be able to provide you with free information regarding any legal issue you have. So call now. Lawyers are standing by for another half hour after the show ends. So we do have one more question, getting back to the trip and fall a little bit, especially if, like you mentioned at Thanksgiving or something, you happen to fall at a friend's house or a loved one's house. How do you maintain the relationship and still get your bills paid? I'm sure that's got to be a tough one.
Well, and I've handled those cases before. Number one, you still have to prove what I just talked about previously, what you tripped and fell on, and they had notice of a dangerous condition. But if that happens, everybody has to remember that you're going after the insurance company, not the person. Now, it was at the person's premises, that's why they have insurance. But you're going after the insurance company. What people, I think, miss in all negligence actions, personal injury actions, the negligence person, they were careless, but that doesn't make them a bad person. So if you're over at a loved one's house, but you fall and you break an arm, or you do something, a lot of people when they fall, they'll get a rotator cuff tear, and they need surgery. They have expenses. So what they need to do is claim on that person's insurance policy, because number one, there'll probably be what's called medical payments coverage. Not all the time, but sometime, and it'll be $5,000, $10,000, $15,000 worth of coverage that will pay the medical bills even if there was no fault. It's also on automobile insurance policies, etc. So that's one source that you can get your medical bills paid from. The other one is the liability portion. If there is negligence, if the reason you fell was they left a dangerous condition there and knew about it and didn't warn you about it, then you can go after that portion of the policy too. But remember, you're going after the policy, not the person. You sort of have to separate that. And in those cases where it's a close friend or a loved one, that's very, very difficult.
Yeah, and I'm sure it depends upon the level of the relationship too.
Yes,
so
yes.
That's just business. That's what it has to turn out to be. It's just business.
It's business, not personal.
Okay, and making this a great segue, speaking of business, we switch gears now to corporate and business law. How does the American Law Firm handle corporate and business issues?
Well, a lot of our business clients are small businesses, and when you talk to them and try to find out what type of business or what type of corporate entity or business entity they should form, that's always an interesting discussion from the get-go, because there are many types. There's limited liability companies, sole proprietors, corporations, such as one of the things that we look at when somebody comes in and says, let's say it's a husband and wife team, or it's 2 or 3 individuals that want to create let's say it's a food stand or a truck that goes around and prepares food in the truck, a mobile restaurant. What type of entity is best? A lot of times we'll tell them, well, what you want to do is try to reduce your individual liability, because what happens if you have employees and they're running around and they go through a red light and hit somebody? The business is going to be responsible, but you as the owner of the business don't want your personal assets exposed. So a lot of times what we'll direct them to do is a corporation. If it's a small business and you have a limited number of shareholders, you could do what's called a subchapter S corporation, which in my estimation is really cool, because the corporation itself is not taxed. It files an informational return. All the income and expenses flow directly through to the owners or the shareholders of the business as a partnership. So what that does is you're not being taxed at the corporate level, and then again when you pay yourself, it's just everything's coming through to you as an individual in your pro rata share, and it's taxed at the individual rate. That's a lot lower rate than the corporate rate, and that could mean you'll put thousands of dollars, tens of thousands of dollars more in your pocket every year. So we talk about that. Some what they call limited liability companies, those are for certain types of businesses. We discuss all of that. So it's a good discussion, but a lot of it centers around how can you run your operation efficiently, and how can you reduce the individual liability to you as a business owner.
Okay, very good ideas. Again, the number on your screen to call, 815-394-1776. You mentioned incorporation. What are the steps involved with that, and some of the reasons, I guess, would a company want to do that?
Well, generally speaking, when somebody comes in and they do want to incorporate, you have to find out what their business model is. It's just not legal. It's just not all the legal steps. What type of business? Because that will tell you what type of entity they need to go into. But generally speaking, you'll have to do what's called the bylaws. You'll have to file the articles of incorporation with the Secretary of State. That'll be a small fee that you have to pay the Secretary of State. Then they'll send the articles of incorporation back. There are certain formalities, such as board resolutions adopting everything that the incorporators did before the corporation became a corporation, so that you cloak or give the umbrella of liability to them. There's a lot of things that need to be done, but they're very simple to do. If you have a well-experienced attorney, they can do it very quickly. They can have you incorporated in just a few days, too.
Okay, so a very important move for any business.
Right, especially if it's a small business. If it's complex, maybe a little harder.
Different thing. Okay, yes. Well, thank you, Mark. Thanks for your time and your insight tonight on this topic. Again, lawyers from the American law firm are standing by right now to take your call. So no matter what the legal topic, the advice is free. The number is 815-394-1776. Lawyers will be taking calls for about another half hour after the airing of the show. We'll be back with a closing statement when Legal Matters returns.